Hi, good evening. Today is January 21st, 2026, and it is 9:43 p.m. U.S. Central Time. My name is Rinaldo Javier Aguiar Marcano, and I'm recording this video from my home located at the 2302 Britton Ridge Drive, Katy, Texas, 77494. And this house is located 300 feet away from the house, in that direction, from the house of Mr. Robert Mueller, who was the director of the FBI for several years, and this comment is relevant to this conversation. Okay, so this is demo D99. Okay, and before I begin this demo, I would like to make a longer introduction to give more context on why I'm doing this, right? And I'm going to say a series of things that may look like random comments, but they're not random. Like there is design on my legal strategy behind the things I'm going to say. Okay. So first, I need to say that I am a protected person according to the Refugee Convention of 1951. That's the first thing I want to say. And I have been submitting reports to the IRS via the official Form 211 about tax non-compliance of several very powerful individuals for the last 15 months, which makes me a whistleblower in the context of the federal law related to the IRS. Parallel to that, I've been submitting applications for reward under the narcotics programs of the DEA for at least 8 months, related to individuals that are named in wanted posters published by the DOJ and the DEA that are part of El Cartel de los Soles, the Cartel of the Suns. And this is the powerful group of narco terrorists that are both military officials in Venezuela and participants in this drug cartel. And the fact that I've been submitting these formal applications for reward, even if the DA hasn't taken action on them, I believe makes me a federal informant, right? And even if it's not the case right now, if they take action in the future based on that information, like for example in a trial, and this is important because Maduro was just captured weeks ago, right? He was brought to the US, he's in New York. So if he goes to trial and the DEA comes across this information and uses it in that trial, that would make me retroactively an informant when that happens, right? And this might be relevant, right? So, to recap about my status, protected person according to the Refugee Convention of 1951, federal whistleblower, and federal informant to the DEA. The other thing I want to say is that my son was taken from the home without a court order from a judge on March 28th, 2025. So it's been 9 months and 22 days, more or less. And since then, all my parental rights have been extinguished without a valid court order. And the child, by the time he was taken, he was 3 years old. And that has legal implications as well. Also want to say that during this process, the Adams Law Firm and Troy Pickett, who are two legal actors in the judiciary system of Texas, have made monetary demands on me using electronic means, based on void orders that they know are fraudulent. And they also made demands for the passport of the child, which I believe is an attempt to move the child internationally. I also want to say that all of this is happening, I believe, because I came into possession of a geographical database that was inadvertently leaked to me by the Venezuelan intelligence services in 2024. And in this geographical database, there are places marked where very well-known terrorist acts have been committed. I'm going to just cite two of them. Well, or not committed, but like are tied to terrorist organizations. Right? So one is the location of the house where bin Laden was killed is marked in this geographical database with the precision of 15 meters. And that's important because it gives an idea. I mean, how did the Venezuelan intelligence knew where bin Laden was before he was? I mean, the location is marked there, and he was killed there, so it had to be marked before he was killed. So how did the Venezuelan intelligence know that? Knew that, right? Another interesting place that is marked in this database is the exact location where the flight M as in Mike, LH as in Honduras, 370 of Malaysia Airlines disappeared in 2024. The exact location of the disappearance of the plane is marked in this database of Diosdado Cabello and these narco terrorists. That event has not been declared a terrorist act, but seeing this database, I suspect it might be, right? So this is at this point a lead, right? It's not an indictment, but it's a lead, right? So I think that those are the things I want to say for the introduction, and all those things are relevant because they are factors in the sentencing guidelines according to federal law. So the federal sentencing guidelines take into account all these factors, right? When, if you commit a crime, to silence, or coerce, or assassinate a whistleblower or a federal informant, right? Anyhow, so with that in mind, let's begin. So this is an interesting demo, right? Because tomorrow, so today is January 21st. Tomorrow, January 22nd at 9 a.m., the Troy Pickett, this lawyer that I was mentioning, had scheduled a meeting for tomorrow at 9 a.m. So it's going to be an interesting event, right? The reason for the hearing is that he's seeking enforcement of those void orders, right? So he's going to try to put me in jail. Enforcement means, for people that are not familiar with the legal jargon, if there is a valid order from a judge or ordering you to, for example, do something and you don't do it, the judge has the power to put you in jail, at least in Texas, right, for contempt of court. And he is seeking enforcement of those orders. The orders are void, and I'm not going to get into details. This is documented in multiple books that I've published. But those orders are void for, at least 7 or 8 different reasons. And if they're void, they're null, right? They don't have any validity, and I'm not going to pay ransom to Troy Pickett. But if he's seeking enforcement of those orders and he knows that I'm not going to pay ransom, the logical thing for them, I mean, the only logical conclusion that I can drive from this hearing is that he's going to seek. I mean, what other form of enforcement can he seek, right? He knows I'm not going to pay ransom. So the only possible enforcement he can seek is imprisonment, right? So that's the purpose of the meeting tomorrow, of the hearing tomorrow, right? On the 387th court in Fort Bend County, Texas. Of course, I'm going to go to that hearing. I'm going to go to that hearing, but to see if they do it, right? Now, here I have to say, I had a very interesting conversation today with Gemini, the chat agent. And this is a longer, I think I'm gonna, I mean, this demo is not a script, right? And I have a series of things I want to say, but the order, may not be ideal. But because I already talked about the introduction, I think it feels like a good place to say this, right? So I'm gonna mention this here. So what happened was, I've been running the pipeline, and the pipeline ran into, I didn't mention this in the beginning of the introduction, but I was also a software engineer working in search ranking at Google for almost a decade. Right? So I'm a person that has technical knowledge about how to write distributed computing systems to work on data problems at large scale, planet scale. So I have this system that I use to fight this legal fight against them, right? That I've developed. And I don't want to give much details about what happened really on the technical side of things, but I've been running into a problem where the cluster has been overheating. Like it's being, it's consuming too much power, and the servers are shutting down, right, because of heat. Like this is not an industrial facility, and I have only limited AC, refrigeration, right, like a cooling for the servers, and they've been shutting down. Then I started debugging the problem. And I'm not going to get into much details on the actual mechanics of the thing, but it came down to basically a kind of an infinite loop, right? Like it was getting the system was getting into a state where it was entering a computation path that was immense. And because I don't have industrial infrastructure here, I could not keep up with the computing requirements, right? Well, not really the computing requirements, but like the cooling requirements that computing processing power requires. And it was ending in a catastrophic path always, right? So I started debugging it, right? And I'm not going to get into the technical details, but basically, the system was finding a series of situations that were deeply conflicting among each other, right? And it has to do with the nature of the RICO, the racketeer and corrupt, racketeer influence corrupt organizations, right? It has to do with the nature of it, right? And it had to do with these things that I was mentioning at the beginning, like the introduction I was giving about my status, the age of the child, all these things. And I didn't know this, right? I learned this after I debugged this and I understood what happened. But it turns out that all these things, and I don't know, I didn't know that because I'm not a lawyer, I'm an engineer, right? But it turns out that all those things are factors that are taken into account in the sentencing guidelines of the federal law. And I didn't even know that this thing existed, right? Because I wrote this system and ingested the data, but I'm not aware of everything that is said in those data sets, right? But I learned about it today, debugging this. And this is I would say it's a beautiful part of law and criminology and penology, right? I didn't even know it existed, right? But as it turns out, as I learned today, in the US sentencing guidelines, they have typified basically all types of crimes and ways of committing those crimes, and with aggravating factors. And so it's a beautiful design, really. Like it seems to have like a base for the sentence, right? So if you commit an offense, if you commit a crime, depending on the circumstances, there is a base level, and it's numeric, like level 19. That means between 1 and 2 years in prison, right? Something like that. Like don't quote me on the numbers, right? But I'm just giving you the idea, right? How the framework works. And then depending on the aggravating factors, like for example, if you kidnap a child to silence a whistleblower, that is an aggravating factor that adds levels to the sentence. And of course, the more levels, the more years, right? And it could get to the point of, I think the death penalty is not included in the leveling. Like that basically means, it's above the scale. Like if you go out of the scale, it's death penalty, right? For crimes that have capital punishment. But anyhow, for example, the age of the child that you kidnap is something that aggravates the sentencing, and that's taken into account into the computation of that sentence, of what would be a fair sentence, according to these federal sentencing guidelines, right? If you kidnap the child to silence a whistleblower of the IRS, that adds levels to the sentence. If you kidnap the child to silence or coerce an informant of the DEA, that also adds levels to the sentence. If you demand the passport of the child, that can be interpreted, according to the sentencing guidelines, as an overt intention of taking the child internationally, and that adds levels to the sentence. Right? If you try to harm a political refugee that has protected status, that adds levels to the sentence, right? So all these things play into account into the sentence that that a person or an organization, like a RICO enterprise, would receive or could receive if they're found guilty, right, of doing something to coerce or silence or assassinate this whistleblower, hypothetically, right? So running the pipeline, basically, the pipeline found that the top members of the I'm just going to tell you how the thing unraveled, right? So the first path was that the pipeline inferred that on the criminal side of things, the members of the RICO enterprise, the top members, could be, the enterprise itself could be found guilty of things that could carry capital punishment. Right? And this is what led to the disaster in terms of the hearing requirements of the servers, because this is probably, the pipeline doesn't have, but I'm guessing, right? Like this is probably one of the largest RICO enterprise in the history of humanity, right? And imagine the implications of that, right? So the implication is, I'm gonna, let's do an intellectual exercise, right? For the sake of the argument, like forget for a second that we're talking about, the situation I'm involved in personally, or specific people. Let's just talk about hypothetical, right? Like no particular person in mind. Imagine a RICO enterprise composed by 10,000 people, right? And these 10,000 people conspire and assassinate an informant of the federal government. According to the pipeline, and this happens in Texas, which also have, the federal law has their own capital punishment, statutes. But Texas, on top of that, also has capital punishment. So imagine this happened in Texas, hypothetically, right? Well, the RICO enterprise would be found guilty of crimes that could lead to capital punishment. And because the liability is shared among the members, all of them could be found guilty of the same crimes and therefore the same penalty, right? So this would mean, I'm just telling you the legal reasoning and why the software basically crashed, right? So this would mean potentially sentencing to death 10,000 people. Right? And this produces a series of implications that are hard to even comprehend, right? Like, how do you sentence 10,000 people to death? And and this is more me thinking about this problem, right? As an engineer. Say for a second that, this is just an intellectual exercise, right? I'm not proposing to execute 10,000 people at all, right? I'm not saying that, but just as an intellectual exercise, what would that mean? Like, if you're a government, any government, I'm not even talking about the US, if you're a government and you found 10,000 of your citizens guilty of a crime that carries capital punishment, how do you operationalize that? Like, how do you carry that sentence? Are you going to build gas chambers like the Nazis? And this creates immediate contradictions with fundamental things and protections that, the right to life, for example, right? So this led to chaos in my system, right? Because my system was not designed to handle these complex questions. So what I did, I started asking, as I'm doing here as an intellectual exercise, right? Like, to try to understand with the help of an AI agent, how scholars and academics in the area of law deal or think about these problems, right? Of these questions, right? And it's I learned. This happened maybe like in an hour, right? Like, but I've learned a lot of things that I didn't know. Right? I learned about the sentencing guidelines. I've learned, but the one of the interesting things I learned is, and this is kind of a dark concept, right? But the individualization of death, and this is one of the things that the pipeline didn't understand, right? That this is one of the reasons why it crashed, because it doesn't have knowledge of this concept, which is another problem on itself. Like, why that topic did not get ingested in the pipeline, but I'll talk about that in a different setting, right? Um, but the decriminalization of death, right? So the concept of death, legally speaking, particularly, government-induced death, is something that is individualized. Even if the RICO enterprise commit a crime, as an enterprise, collectively assassinate or coerce or kidnap the son of this hypothetical whistleblower, um, if a death sentence is imposed or is sought by prosecutors, it would have to be sought individually. They cannot seek a death penalty against the enterprise and then distribute it to everybody. Right? They can't do that. They have to individually prosecute each one of the 10,000 people and then seek 10,000 death penalties, right? Individually, and some of them will might win or may appeal. Different things will happen to different people, right? But it's a concept the pipeline didn't have, right? So that was the root cause of the bug, right? That it was falsely assuming that the liability and the penalty would be shared equally, right? And it's not the case. But then after I was in this exercise, right, talking to this Gemini chat bot, I started asking other questions that I saw were also contributing factors in this crash, right? So there's other areas of law besides the sentencing guidelines that are very interesting and that also overlap with the questions and the topics that we've talked about and discussed during these 99 demos so far. Um, um, so the death penalty is one of the questions. The other question is piracy law, right? So piracy law, and I'm not a legal expert, so I'm just gonna kind of mention what I kind of know or what I've seen, right? But it's one of the oldest concepts in law, right? And it was piracy law was created, to deal with pirates, like real pirates, centuries ago, that were terrorizing the international commerce by capturing or attacking vessels in open sea. But the principles of piracy laws are interesting because the universal applicability, well, it's not called piracy, I think it's called admiralty law is the legal term, right? But it has very powerful applicability implications worldwide. Because basically what it says is that, it says many things, right? But one of the interesting things that it says is that according to piracy law or admiralty law, if somebody is declared a pirate, and what being a pirate means is typified, like it's not wearing an eye patch. This is typified in these concepts, and it has to do with activities that pirates did centuries ago, but also these laws have evolved, right? And now what the definition of what a pirate is different than 400, 500 years ago. These concepts have modernized, right? And there are typifications within admiralty law that are applicable to members of this organization. And this is interesting because this gives jurisdiction. One of the interesting things that these piracy and admiralty laws apply, the principles, is that if a pirate is found in another country, even if say that the pirate is found in I don't know, in the coast of Somalia, right? And even if the crime that they committed is not against a U.S. ship, if there's a U.S. ship nearby, they can pick them up, right? So it gives tremendous powers to capture and to prosecute people in other countries, right? So it could be an amazing tool, right? Let me check one thing here real quickly. Yes. So so basically what I'm talking about is the intersection of RICO death penalty, statutes and sentencing guidelines, and admiralty law, jurisdiction and penalties, because there's also death penalty for pirates, right? For certain types of crimes, like killing the captain of a ship. And these things have been modernized, right? But originally, the idea was, if you kill the captain of a ship, you die. So anyhow, it's an interesting intersection. As you can see, there's multiple avenues in which the members that are participating in this could end up sentenced to life or worse. So it's a tricky situation, right? But then my conversation with the chat didn't stop there. Then, because I also saw in the pipeline the implication of terrorism, right? And that's why I mentioned, it's not like I inserted that comment. I've known this for over a year, and I've said this in multiple places, and it's published in the books that are printed and available on Amazon, right? There are points marked in this database of the Venezuelan intelligence that are directly tied to either terrorist groups, terrorist attacks, or events where many lives were lost. Right? Like, for example, the house where Osama bin Laden was killed, or the point where this plane of Malaysia Airlines disappeared. And there's multiple other examples that I found, right, in this database. And they're documented in the book. So this is important because this brings into the table another segment or another, how do you call that? Another area of law, right? Which is terrorism, like the terrorist statutes, right? Terrorism statutes, statuses. I don't know how to say it. The areas of law that deals with terrorists, right? Because, well, if the database of Diosdado Cabello, who is a man who is wanted for narco-terrorism, this is not something that I'm making up, right? Like, the DOJ already categorizes Diosdado Cabello as a narco-terrorist. And the database that he leaked to me contains all these places where terrorist attacks have happened. The obvious conclusion is that this network has ties to these terrorist organizations. There's no other conclusion you can draw from that. And if you are an attorney, or you are a judge, or you are a judiciary actor working to silence or coerce, or worse, a whistleblower that is trying to give this information to federal authorities, that makes you part of the terrorist organization and of the terrorist acts that organization has committed on the past, right? So here I learned a lot of things about these terrorism laws and statutes, right? Like, for example, the statutes of limitations are not the same for terrorist acts as for regular crimes. So, if you commit a crime, there's a certain amount of time after the crime in which that crime can be prosecuted. After that, the prosecutors cannot do anything. But in the case of terrorist acts, this time could extend to 18 years. So, for example, the Malaysia Airlines thing, if determined to be a terrorist act, could be prosecuted today, right? In 2026, no problem, right? And if you're a lawyer working to silence the whistleblower that has this information, either by coercing them, kidnapping their child, or doing something physical to the whistleblower, you are part of that terrorist act because you're working to cover it up. So this has tremendous legal implications for this network and for the people that are actively doing this and have this hearing scheduled tomorrow, because this pierces the protections that they have for being officers of the court. Like, in general, if you are a lawyer, you have certain protections. Like, you cannot be found, I cannot sue a judge that is making a decision in my case, right? Because they have judiciary protections. But that gets completely destroyed if they are doing this in the context of a terrorist organization, right? Or to conceal terrorist acts that have already happened. So, and the sentences for these things are immense, are very, very severe. Like, you know, uh, falsely imprisoning a whistleblower carries life sentence according to federal law. Imagine that. I mean, just taking the liberty away of a whistleblower that is giving information to the federal government on an act of terrorism carries life sentence. Just putting the person in prison for a while, right? And it goes, that's the starting point, because the crimes, I mean, that is one of the less severe crimes, right? False imprisonment is less severe than kidnapping, right? And, putting in jail a whistleblower could be considered kidnapping if the court doesn't have jurisdiction, for example. That would be a kidnapping under the color of a state law. Taking the son of a person from their home without a valid court order, or restricting access of that person to their son without a valid court order, could be considered kidnapping, especially if you're making monetary demands, like asking for paying the rent of somebody. That is a form of ransom, right? I don't know. It's interesting, right? It's super interesting to me to see. I mean, this bug, my server's crashing, led me on this path of academic discovery of things that I didn't know, that let me see that the level of liability that these people have hanging over their head is immense, right? They should be thinking on how to return the child quickly, because also the time that the child is kept from the targeted whistleblower is a factor in the sentencing. So the longer you keep the child, is the longer the sentence, right? So it's it was an amazing development, right? Like I feel like I was blind, but now I can see. Yeah, so I think I don't know. I'm thinking of whether I should publish that chat as an appendix in one of the books. Like, if somebody's curious about these things. I mean, I already did the exercise of asking all these questions, right? I don't know if it would bring value to anybody, but I'll think about it. Yes. So, sorry, I'm just thinking about, because I don't script the demos, so I don't know what is a good. I mean, I have a series of talking points, but I'm just looking to see. What is a good next step here. Yeah, so let's talk about a little bit about the evolution of the last few days, right? So the last few days, the last, I don't know, 2-3 days have been very, very interesting, because I feel like they've made a ton of mistakes, like legal mistakes, right? Like incredibly horrible mistakes. And of course, I exploited them, right? I used them against them. But let me start by saying that the informant told me, I'm not going to say when, but the informant told me that they've been, because, after I recorded demo D98, in which I described the 3 ways that they were working on to get me into prison, right? The information was so accurate that what I said in that demo, well, please watch it if you have time, that they made the decision to stop communicating using the secret internet that they have. So, they have a secret internet provided by the Communist Party of China using the cars as relays. All this is described in the book, but they have a secret internet, a parallel internet separate to what you and I know, right? It's an internet, it's the same thing, but it's separate, it's secret, right? It only works with their devices, with their apps, and you can only get messages in specific physical places. Like, it's like internet with a twist, right? With a Chinese twist, and with the Diosdado Cabello twist. But so So they were using that internet to communicate and coordinate and everything, right? Because it's safe. Like they thought it was safe, right? But after I recorded that in demo D98, according to the informant, what he told me was that they made the decision to stop communicating in that way. So now, no phones, no messages, no, they physically get together and talk, right? But I think, and I'm speculating, right? But I can see the correlation between the informant telling me that and they making more mistakes. Before, they didn't make so many mistakes. They made a lot of mistakes. Like, for example, Roy Pickett saying in writing in a court filing on November 7th that the void orders that I'm talking about that are null, that give them no rights to keep the child, those orders, he said in a court filing on November 7th that he filed with the court, that those orders were signed on October 15th, which contradicts his own statements to the First Court of Appeals in front of Chief Justice Terry Adams, who is related to William Kyle Adams, who is the owner of the firm that introduced the fraudulent document on October 10th, the notice of entry dash temporary orders to supposedly trick the First Appellate Court, right, into dismissing my petition for writ of mandamus. I know it sounds complicated, but the long story short is that Troy Pickett contradicted himself in writing, right, about the signing date of those orders, which is a confession, right, that the orders are void and null, right, which makes this kidnapping, right, what they're doing, kidnapping of the child to coerce me. The person that has the database of Diosdado Cabello, and in that database is all these places tied to terrorist groups marked. And Diosdado Cabello being a man wanted by the DOJ and the DEA. Right? So anyhow, after they made that decision of changing their communication style to in person and no phones, everybody put your phones on the closet or something like that, right? They started making more mistakes, legal mistakes, right? And it's been, they have been giving me low-hanging fruits to exploit, like there's no tomorrow. Honestly, I've been so busy destroying them, legally speaking, that I haven't had much time to even record this. Which brings me to another point. It has gotten to a point, and I published this on a book, and I'll show you the book in a second. But it has gotten to a point where two separate courts, one on the federal path and another one in the state path, stopped receiving my documents. So it's gotten to a point where I file a document and the clerks ignore the filing. They don't even respond. They ignore it. Like the filing doesn't exist, right? And of course, imagine they're going to say that they're ignoring it because I'm difficult, because I'm filing too many. That's not, the clerk has no, the clerk can reject filings for things like formatting, right? But still, she has to notify the party that the filing is rejected, right? She cannot just ignore it. The clerk doesn't have discretionality on whether to, process the filing or not, right? That is obstruction of justice, right? And again, it's not an isolated crime. It's obstruction of justice in the context of protecting this RICO enterprise run by Diosdado Cabello, who is a man wanted by the DOJ on narco-terrorism. Right? So the clerks that are doing this are directly covering up terrorist acts, which, as I said, and they are doing that not for, randomly. They're doing that to silence a whistleblower by keeping the child kidnapped. Right? So that could carry life in prison. So think about it, clerks. Like I don't think it's worth it. Like I don't know how much a clerk can make, even with the crypto payments and everything. I don't know if it would be worth life in prison for that. Right? Think about it. But anyhow, it's gotten to the point where the clerks just ignore my filings, right? Including, and this is, the Fifth Court of Appeals. I'm not going to say that I condemn it, that I accept it, right? But it's a court of appeals. But the most interesting to see case is the 387 court, because this is the court, this is the trial court. This is the court where my case that it's open and ongoing. I'm an active litigant on that case, and they're ignoring my filings. So imagine what that means. And I mean, it's even worse because I'm the respondent. I didn't initiate this action. They initiated the action. I mean, Troy Pickett and William Cal Adams. Right? They are the ones that initiated the action. So if they initiate the action, I should have at least the right to respond, right? At least to file a response. But I can't because the clerk doesn't let, I mean, I file the documents electronically, but the clerk doesn't process them, right? They never docket them, they never stamp them, they disappear into the void, right? So it's gotten to a point where, I mean, the obstruction of justice has gotten to a point where I'm not even allowed to file documents on my own case, where I'm the respondent. Imagine that. So basically, the setup right now is that only Troy Pickett can file documents to impose orders, void orders, right? And to seek enforcement and put me in prison for not complying with the void orders because they're void. And only him can file documents. I cannot even file. Right? So my only role in this process is to take orders, void orders, and enforcement actions. That's my role. I'm not really a litigant. I'm like I don't know, and I don't mean to be dramatic, right? But if I'm trying to think, what setup in society resembles this setup in which one human being is able to seek actions against another, and the other human being can only receive those actions, cannot respond. The only scenario that I can think of is a prisoner of war. You know, like, I don't know, when the war in Cambodia, for example, happened, or in Vietnam, right? People got captured, the plane got shot down, the pilot got captured, they got put into a hut in the jungle, and they would be punished corporally and, you know, forced labor, and they had to take it. Like they had no recourse. They couldn't go anywhere to seek recourse, to seek relief, right, from this abuse. It's the same situation. My only role in this process at this point is to take whatever Troy Pickett sends, like orders, temporary orders, hearings, more temporary orders, enforcement, like whatever he thinks that, you know, that he wants to do, he can file and do it. But I cannot even respond. I have to take it. Right? Only take it is my role. But this is interesting because I can see the correlation, right? This happened after I, a few days ago, in Demo D98, mentioned the chicken wing and mentioned the strategy of my software. But the strategy of my software is basically to take this to the chicken wing and similar actors on the state side. And only after I said that, then the situation, their strategy changed. Before that point, before Demo D98, I could file documents and they would accept them, right? But after Demo D98, they stopped accepting my documents because they saw, like, I'm speculating here. Well, not speculating, like the informant told me that they did understand who Chicken Wing is. I mean, the network, when I say Chicken Wing, they, in a matter of minutes, understood who I was talking about. I'm not going to reveal the name of the chicken wing, but they know who the chicken wing is. And the informant told me and asked me if that was the chicken wing. And I said, I answered to yes, the answer is yes, that's the chicken wing, right? So at this point, they know who the chicken wing is. And of course, I know who the chicken wing is, right? And only after I revealed that on Demo D98, they changed their tactics. And now the tactic is he can't file anything. We're not going to accept any of his filing. And this happened in 2 different courts at the same time, within 20 hours difference, 24 hours, within 24 hours. In 2 separate courts, one being the 5th Court of Appeals on the federal branch, and the other one being the 37th Court, which is the trial court in which I'm the respondent. In the 2 courts, they stopped taking my filings. I file and they're silent. Like it doesn't come back. They don't say it's wrong. They don't say anything. They just don't file it in the docket, right? But so this is because they understand that every document that gets into the docket is going to be evidence against the chicken wing and the similar actors on the other side, which I call the chicken wings in plural, right? So the strategy has shifted on their side to, well, let's not allow any more evidence to go in, right? But this is silly, I mean, I think, right? Because then this is now an overt act of obstruction of justice using the court. And this is also relevant because there's precedents in which the courts have been considered by federal prosecutors and found guilty as the, well, not the courts, but the court has been considered, in RICO cases, the question is, what is the enterprise? In these, scenarios that I'm describing, the RICO enterprise would be El Cartel de los Soles, right? The criminal organization run by Diosdado Cabello, right? That would be like the most visible legal entity that the government could prosecute, right? I think. Because, for example, Maduro is already in the US, right? And he's the head, the official head. The head is really Diosdado Cabello, right? But the figurine that he had in there was, as head, was Diosdado Cabello. I mean, and this is just a commentary from me, right? I'm nobody to comment on this. Maybe I'm wrong, right? But I think what happened is that Diosdado learned from history what happened to Noriega. And he said, well, you know what I'm going to do? I'm going to put somebody as president. So if anybody gets captured, it's not me, right? And so that's why he's the number second man in Venezuela, right? It's because he put the number one so that one gets captured, just in case, right? Like a human shield. I mean, you have to hand it to him, right? He's pretty smart. So anyhow, but as I was saying, right, there's been precedents, and I learned about this chatting with Gemini, right? In the US, not too long ago, in which the criminal enterprise was considered to be the court. And there is an interesting, a landmark case, they call it, which was the Cash for Kids, in which a couple of judges conspired to shut down juvenile detention centers, I think it was, that were operated by the government, to then allow private interests to build their own and operate their own and charge the state for the care, quote unquote, of the children, right? Or the juveniles that were detained there. And then after that, the judges made sure to send a lot of kids to prison, to these juvenile detention centers, so these facilities would make more money and they would get a cut. In that case, for example, the criminal enterprise was the court. Of course, there's a legal distinction here. In reality, the people that were, the entities that were found guilty at the end was not the court, were the actors operating in the court, right? The judges, right? For example. So the judges were found guilty, not the court. But the criminal enterprise, in terms of the legal language of the documents, was the court, because they were operating it as a criminal enterprise, right? And here, this is a fascinating. I don't know. I don't know if this is a good way to say this, but I think, one of my dreams would be that after this, I can get an internship at the DOJ. Like, I find this so fascinating. That I don't know. I think maybe I will apply for an internship or something, or with the FBI. I don't know. Like, but anyhow, there is another technicality here, right? Is that a judicial actor, when they're performing their duties, they carry judicial acts, and those judicial acts are protected. For example, if a judge gives an order, a real order, not a void order based on a fraudulent document, but a real order, that order is a judiciary act, right? A judicial act, and that is protected. They cannot be charged criminally for that. But so the interesting thing, right, the way this bill was pierced by the prosecutors was by alleging that, for example, taking the bribes was not a judicial act, was an administrative act. They were taking money, right? They weren't rendering orders, and that is not protected. So the bribery, the accepting the bribes, is not protected. And that's where they got them, right? And also for tax evasion, for not reporting the bribes to the IRS, right? Which, remember, I am reporting people to the IRS precisely because they are receiving payments on crypto payments that are marked in this database. So it's a fascinating field of law. Right. So Yes. So I'm just trying to to see what things not to say, because there's certain things that I don't want to say for strategic reasons, I guess. Um, yeah. So anyhow, after I said those things on demo D98, the strategy on their side changed, and now I cannot file any documents. But then, because they they were pressing on with this hearing tomorrow, I filed a supplement. Oh no, what happened was Pickett responded. He filed a response to my motion to recuse, which, it's a motion to recuse against the judge. Like, Pickett has no business responding to that. But anyhow, that's the path he took, and he filed that response on the 16th, and I have the document, file stamp, and everything, right, with the date of the 16th. So what I did, I filed a response to his response, to get more evidence, right, into the record. And this is the first document that the clerk ignored. And I filed this document on January 19th. And today being January 21st, 2 days later, the clerk has still not docketed the document. It's missing from the docket, right? So what they did, because when I filed this document, I'm going to give more details here, so the DOJ, if they ever investigate this, they will be able to track this down, right? So when I filed this response, because this is a response to Pickett's response, right? So a response to a response. So in the e-filing system of Tyler Tech, there is a field that asks you, what type of document is this? What type of filing? Is this a motion? Is this a response? So I selected response because I'm responding to Pickett, right? To Pickett's response. And I filed the document. The document, in fact, let me share. Let me show you, right? Because it's an interesting document. It's an interesting document. So I'm going to share my screen. Just a second, okay? Oh, sorry. Okay. So I'm going to share this. Okay. So this is the evidence Google Cloud Storage bucket that I'm putting together, right? For the DOJ, hopefully. So in this folder, there is a subfolder in this docket. There is a folder that says court, that is called court evidence. And in this, there is this thing called the 387th court. And if you go to the clerk, there's the cases of obstruction that I was describing, right? And you have here all the evidence that you will need. And there is a folder that's called DOJ that has the filings, the supplements that I filed with the DOJ that mention these incidents, right, with the documentation. And I think on the 7th supplement is that particular document that they've been ignoring for 2 days at this point, right? And this is highly unusual. Usually, the docketing takes less than 2 hours, usually, right? Very rarely more than 2 hours. But it's been 2 days, and they don't docket it, right? But it doesn't end there. Like, there's a lot of anomalies that they did here. Oh, no, it's not this one. It's not the, oh, sorry. It's not the 7th. Let me see. Okay, I'm going to show you the document. I think it's the 6th supplement. Yeah, so this is a document they are killing, basically, ignoring, right? But I mean, it's silly because the document exists, and I have the notice of service. I have proof that I served them the document. So yeah. Even if they don't docket it, so this is what they did, right? So remember, Pickett had filed his response on January 16th, and he had gotten The index, I think 147. But then on January 19, I filed my document, right? Which would have been like index 150, something like that, right? So what they did is that they took Pickett's document and they replaced mine by Pickett's, effectively deleting, overwriting my document, right? So now Pickett document is the index 150, like they took my index number. But of course, these in the docketing system of the court, because they cannot change the code of that docketing system, right? They can control it to that level. So the date of the filing changed. So now Pickett filing in the docket shows January 20, which is the date 4 days after he actually filed it, and it was actually accepted by the clerk. So there is obvious, right, that they did it, that they manipulated the docket to hide my filing, to hide the fact that I filed this response. So basically, they making it look like it was a mistake, right? There was a clerical mistake, and because the two documents say response, the clerk got, quote unquote, confused and filed Pickett document twice. Right? That's what they're going to say, right? That it was just a clerical mistake. But this is important. I'll show you why they're doing this, right? The reason is because in this document, and here's the service certificate showing that I filed this on the 19th, right? And this is the actual document. It's a consolidated reply and a supplement in support of the third motion to recuse, right? It says multiple things. I'm going to start by saying what it says, right? It says, because in Pickett's response, and this is why this is a response to Pickett's response. In Pickett's response, he did exactly what I anticipated that he would do in demo D98. In demo D98, I said, before even looking at his response, before I even looked at the response, I said, the informant told me that this is what the response says. And I said, right, that he was going to say that that my third motion to recuse was frivolous, right? That I was doing this to delay the divorce, which it's absurd. But that's what the informant told me that he said before I even read it, right? I opened the document after I recorded demo D98, and in effect, the informant was right, 100% right. That's exactly what Pickett did. And in demo D98, I said, if he does that, that's a mistake, because this will open the door for me to mention the longevity of this conflict of interest of this judge. Because I published a book in July 2025 that has this judge and Susan Brown, the Honorable Susan Brown, in the cover of the book. How can they be impartial if they're in the cover of my book that talks about judicial misconduct? And also, I've reported Judge Brown and Judge Telfer and Pickett to the IRS months ago, right? So Pickett is, this is what I said in demo D98. Pickett is, if he does that, he's opening the door for me to put all this into evidence, right? So that's exactly what he did. And of course, I'm filing this response to put everything into the evidence, and that's why they are killing and ignoring this document, right? But the other interesting thing, and this was picked up by the pipeline, is that in the hearing of September 8th, there was a mention about the books, September 8, 2025. And this mention was made by Morgan Heipner and by Judge Telfer himself. Judge Telfer asked me while I'm on the stand if those are my books. So this is direct proof that Judge Telfer knew about the existence of the book at least since September 8th, 2025. He should have recused himself voluntarily without me even filing a motion for that months ago, and he didn't, right? So this is what this document that they're trying to kill says, that all of them knew about the existence of the book and the conflict of interest of the judge, and they haven't said a word, and they keep actively denying the motions to recuse. And the other thing that they said, that Pickett said, is that I was trying to delay the proceedings, and this is also factually untrue and demonstrable. That is not true, because in the same transcripts of the court, if you look in October 10th, in the hearing of October 10th, you will see that I was begging the judge for no more delays. I was objecting to more delays when he shut me down. Here also the pipeline found something very interesting. In that hearing of October 10th, 2025, which is the date in which William Cal Adams and Morgan Heibner enter into the record the fraudulent document, the temporary orders, notice of entry dash temporary orders, which was really a notice of hearing. In that hearing, I'm saying this to the authorities if they investigate this, right? If you listen to the audio, you will see that everybody, the judge, Morgan Heibner, the scheduler of the court, everybody calls me Mr. Espina. Imagine that. This is strange. I mean, Espina is the last name of my former partner. It's not my last name, right? So the way it looks, if you hear that transcript, is if you read that transcript, or if you hear that conversation, is that this is a divorce and that she took my last name and that my last name is Espina, right? That's what you would think as an investigator, but this is not true. My last name is not Espina. I did not take her last name because that I don't know. I don't think that's usual, right? That the man takes the last name of the woman, and we're not even married legally. I cannot, even if that was something that was possible, we're not legally married. And she didn't take my last name either, right? So, but this is important because remember, this date of October 10th was a pivotal day in which they took the step of filing this fraudulent document to then deceive the First Appellate Court 4 days in the future, right? Which on itself shows premeditation, right? But I mean, and this is the inference. The inference is that all these actors were calling me Mr. Espina in case there was an investigation and this transcript was reviewed, my name didn't pop up in this transcript at all, right? So nobody would understand that when they're saying Mr. Espina, they're really talking to the whistleblower that they're silencing with this deceit and fraud, right? Well, they haven't silenced me. They're trying to silence, right, by coercion. But this is important because it shows premeditation. And not only premeditation, it shows concert among at least 3 individuals that are calling me Mr. Espina multiple times in this hearing, right? Every time they talk about me, they say Mr. Espina, right? So this shows concert and premeditation on a hearing that turned out to be pivotal in the consummation of a crime against not 1, but 2 Texas courts. And again, the premeditation factor is one of the factors in the sentencing guidelines, according to the federal sentencing guidelines, right? So that's why I'm mentioning that. Anyhow, if you look at that transcript of that October 10th, 2025 hearing, which happened over Zoom. So all this must be recorded in Zoom, right? In Zoom servers. I'm talking about Zoom, the communications, the video conference company. So if you read that transcript, when they say Mr. Espina, they're not talking about Mr. Espina. It's me. It's they're talking about Aguiar Marcano. But they intentionally are calling me Mr. Espina to create confusion in case there's an investigation. That shows that they knew that they were committing a crime, even before filing the document, right? I mean, the notice of entry temporary orders, which led to this point today. Okay, so in this document that I filed with the 387 that the clerk is ignoring and she doesn't want to docket it, I also included as an exhibit the actual Form 211s with the IRS that I filed reporting Judge Brown, Judge Telfair, and Troy Pickett to the IRS. And of course, I redacted every other name to not make this, a political issue. Or I removed everybody, but I only left visible the judiciary actors that are relevant to this reply, to this response, right? I mean, what I'm saying with this is that the 2 judges, the judge of the trial court and the administrative judge that would eventually review this motion to recuse, both of them, I reported to the IRS months ago, right? Before the motion for sanctions, before the motion for enforcement, before the hearing was scheduled. So this is not a dilatory tactic. Like, this is real. And this happened before all of these events, right? But the important thing is that this shows that they cannot be impartial. Right? This has to go to another judge that cannot be decided by who that judge is going to be. Neither Judge Brown can make a decision, should make a decision on this motion because I reported her to the IRS. How can she be impartial? And also, she should not decide who is going to be the judge. Right? So I don't know what they're going to do with that. And you have here the certified envelope, the certified mail that this was used to be sent to the IRS, and you have the signature of the employee of the IRS that received it. And you have another form similar to that, but for Troy Pickett, because I reported them in 2 different forms for technical reasons. And you can see the address of Troy Pickett that my system has for him, which is 23212 Red River Drive, Katy, Texas, 77494. And you have also the envelope for Troy Pickett. And crucially, this is the cover of the book that I was saying, that Josh Telfair is in the cover of the book and Susan Brown is on the cover of the book as well. And so I included the original cover of the book, the art, right? And remember, this is generated algorithmically based on the data in the database of Diosdado Cabello and the Venezuelan intelligence. Like, this is not a collage that I made by hand. This is done algorithmically. And here's an annotated version that shows you exactly where Josh Telfair is and where Josh Susan Brown is in this cover, right? So this shows that, you know, they're in the book. It dates from July 31st, 2025. And I also included the receipt in which the order in Amazon in which I paid for the book that I sent to Morgan Heibner, which is the book that she then got into evidence as Exhibit 37 and 38 of the petitioner into the September 8th hearing. And she is on the record asking me if those are my books. And the judge, Judge Telfair himself, he asks me directly when I'm on the stand if those are my books. Those books were purchased in this order. Right? And you can see that this was in August 26th, just a few days before that hearing, right? So I sent her the books. I mean, Morgan Heibner, who works at the Adams Law Firm, which is controlled by William Cal Adams, who is related to Chief Justice Terry Adams. I sent her that book, those books, I sent her 2, on August 26, 2025. And that hearing took place on September 8th, 2025, right? And she put them into the evidence. Like, of course, she did it like to imply that I'm crazy, right? To call me crazy. To supposedly, in her mind, to justify the psychiatric evaluation. But it was a terrible mistake because she's talking about that in the record and she put them into evidence, and the judge asked me directly if those are my books. And I said yes, right? So the judge knows that he has a conflict of interest, and he's on the record asking me the question if I authored the books, and I said yes. How can he have not recused himself until this point? It's just incredible, right? Just by pure ethics, he should have recused himself immediately, right? But instead, he did all this, right? Stripped me from my parental rights, entered the void order, then entered sanctions, and now, tomorrow, he's gonna find me in contempt, right? And put me in jail. Let's see. So anyhow, this is a document that the clerk is refusing to file, okay? So I'm gonna move on from that topic. So on the because I said the 2 clerks, right? So that's the clerk of the 387th, and a similar thing happened with the 5th Court of Appeals. I filed for a petition for writ of mandamus there, which is ongoing, but I filed a motion to stay the trial court proceeding of tomorrow. And I explained this before. The clerk made a ruling on jurisdiction as if she was a judge, right? Then I filed a different motion saying, well, I'm not going to file for the stay. I'm going to file for, so this is a motion asking the court, I'm directing this to the court, to compel its own clerk to force them to file the document, right? Because she's refusing to file it. And then she replied saying, I'm not going to file this because you're asking for the same thing, which is not true. I'm not asking for a stay. I'm asking for the court to order her to file. This is a different issue, right? But she again made a ruling on that as if she was a judge, right? So she did it twice. And she flat out tells me in that email that she's going to ignore all my filings from that point on. Imagine that. So she's telling me that I don't have access to the court. She's blocking my access to file in my own case, right? So it's crazy, really. So, and these two blockings from the two clerks of these two separate courts, one being federal appellate and the other one being state trial court, the clerks in both courts within the same 24 hours periods blocked my filings in a way that I cannot file anything. So at this point, basically, the two systems collapse, right? Like, I cannot file. I cannot file in any court at this point. I can only take. I cannot file. But this happened within the same 24 hours period and only after I mentioned the chicken wing in demo D98. So definitely, right, this tells me that the chicken wing is one of the organizers of this because, and I've talked about this before, like I understand the concept of personal liability. These people in the network, the people that are high up, only take action either way, right, when they see personal liability. When it's not their own skin that it's at play, they, if they have to sacrifice 10 judges, they will do it. I don't know, like, this is probably a different conversation, right? Yeah, this is more a philosophical conversation. I'm not gonna get into that, right? But the psychological dynamics on that are interesting to me. But anyhow, I understand that if the tactic change is because the mention of the chicken wing was something where the chicken wing himself saw liability, right? Because otherwise the tactics wouldn't have changed. So that means that the chicken wing is an organizer. He's not, I mean, I know that chicken wing is very important and irreplaceable. And, I've been thinking about this, right? Well, think about it, right? I think the irreplaceable is a good hint for authorities, right? If you want to know who the chicken wing is, like, think about what irreplaceable means, right? In this context of this area, right? Okay. So the next thing I want to say is that in that bucket, in that Google Cloud bucket that, I imagine, right, that the authorities could probably have access to that bucket, I uploaded all my messages for the last 2 years, I think. I'm talking about my text messages, right? And I have messages that with people like Penelope Suarez, Francisco Castillo, Ana Codalo, and many people, right, that are part of the network. And I don't know, I think it could be a good source of material for authorities to, establish timelines and, actors and things like that. So it could be, I'm just mentioning that they're there, right, at your disposal. You just have to take them. And importantly, in those messages, you will find the extortion messages sent to me by the Adams law firm in April 2025 after the child was taken. And this was done to silence me, right? Because I was researching addresses in Caracas that are marked in this database that Diosdado Cabello leaked to me. And of course, Diosdado Cabello reacted, right? So you will find the messages, and the way the messages look, right? They were sent by proxy, right? By this technique that I also describe in the book, how they impersonate the phone number of another person, right? This is described in the book. But if you look at the messages, right, they're coming from the Adams law firm. I know that for a fact, and I know that because the informant told me. And so if you look at the messages, basically what they say, when the child was taken and I was begging to be able to see my son, they had my child secreted for 50 days, 49 days, that I didn't know if he was alive, if he was in the country. I knew nothing about him, right, for 49 days. So during this time, I was begging to see my child, and their answer was, when you get better, you will see him, right? That's literally what those messages say. And then I asked to the Adams law firm, by proxy, right, because they were impersonating that other phone number, but I asked them, but what does this mean exactly? And their answer was, you will see him when you get better. You will see your son after you go to a doctor and after you take medication. right? So that's the coercion, right? So only if I accepted to see a doctor of Diosdado Cabello and take whatever Diosdado Cabello wanted to give me orally, then I could see the child, right? That is the coercion. That is the proof of coercion, right? That's the ransom, right? And here, talking about the things that I've learned, talking to ChatGPT, to Gemini, uh, ransom does not necessarily has to be from in terms of the legal implications of this and the sentencing. It doesn't have to be money. Like, for example, the silence of a whistleblower can be considered a ransom in the context of the sentencing and the from a criminology and penology point of view, if asking for silence is the benefit, right? That's the ransom. So it doesn't have to be monetary, right? Because the silence has a monetary value. I mean, if they can keep, shipping drugs because the whistleblower didn't talk, then, if they can keep evading taxes and not paying on the crypto payments that they receive, that's the monetary value attached to the silence, right? That they're seeking from the whistleblower, that they're coercing, right? Yes. Yes. So I'm going to move on to more, finer topics, like smaller topics, right? So one is that there was a message in the, I'm not going to get into details of how my system works, but there was a message that was a stock that I did not see in time, and I saw it after, and I did not mention it when I record the demo D98. And it's about that phrase that my former partner told me, that she said, "You are recording me." There was a message that I did not see on time, and when after I saw the message, I remember, like, she did say that, right? So the full phrase that she said, so the informant basically told me why that was important, right? The phrase that she said was, "You are recording me and then you are publishing it, I don't know where." That's exactly, I mean, it was in Spanish, right? But if I translate it, loosely translated, would be something like that. The informant told me that what they're doing with that is seeding, supposedly, evidence that she had an expectation of privacy on, I think it was June 30th, when that recorded conversation got recorded, in which she told me several things that are very dangerous for the network. One was that David S. Perwin, who is a former judge that was appointed to the bench by Governor Greg Abbott, he, acting as a mediator, working with both of us, he made the decision that we could not mediate. I had asked him to relay a simple request to the other party, and he did not relay the request. He made the decision himself, which is, of course, a violation of our trust and a profound abuse, right? Like, I feel violated by the fact that he did that. Like, we could have resolved this issue in that mediation, right? And I would have had access to my child for the last 9 months. And because of his decision and that criminal action, I have been prevented to see my child for 9 months. So that is in that recorded conversation, which is a transcript that is also in the DOJ book. So what they're doing with that statement that she made, that you are recording me and then you are publishing things, I don't know where, is to then establish in a federal court, when this inevitably goes to trial, that she had an expectation of privacy, a reasonable expectation of privacy, and that transcript should not be admitted, right, into evidence. Which I think it's silly, right? Because, like, they think this is going to be litigated in one of these small courts. So that's what they're doing that, right? And also, in that same transcript, she tells me that the motion for a psychiatric evaluation was a litigation strategy designed by the Adams law firm to coerce me into a settlement in mediation. She tells me, if you had agreed to what we had prepared for the mediation, there would be no need for a psychiatric evaluation, right? So, and remember, put this in context with the messages that the Adams law firm sent me in April, saying that I could only see my child after I went to a psychiatrist and took medication, right? And you put the two things together, you can see the coercion and you have the proof of the coercion. I'm mentioning this humbly to the DOJ if they see this video. So you have on one side the messages, and on the other side you have a recorded conversation where the petitioner is saying that this is exactly what the Adams law firm designed, right? And that David Esperwin helped perpetuate the scheme and also made a critical pivotal decision in the process to make the scheme possible for 9 more months, right? So to keep the child kidnapped for 9 more months. That's a direct consequence of David Esperwin, right? If he hadn't been on the picture, I would have seen my child for the last 9 months. So, you know, put that in perspective. So yeah, so that's the reason why she made that comment, right? So they're seeding that to then fabricate that evidence later to say that she had an expectation of privacy, which of course she didn't, because in the recording you can see that she looks directly at the camera. And I think I don't recall exactly because I haven't seen that recording in months, but I think she even asks me in front of the camera if the camera if that is the camera. Like it's a GoPro camera that is big, it's very visible, and she looks at the camera and she asks me a question about the camera in the video. So how can you have an expectation of privacy if you're talking in front of a camera? I mean, that's crazy. But anyhow, I'm not going to litigate that here. Okay, the other thing, this is interesting, this is more technical. The informant told me that the Pixel phone that I have, the older one, I have 2 Pixels, right? I have a Pixel, I think it's 8, and I have a Pixel 7 or 8, and I don't know. I have 2, right? The older one, he told me that it's heavily bugged, right? That they can basically listen and watch the camera real time on that thing, even if the radio of the phone is turned off. And he told me something that they were doing that is very ingenious. And I'm mentioning this more on the engineering side of the aspect of this technique rather than the fact that the phone is bugged. I mean, the fact that the phone is bugged is not a surprise to me. But the how ingenious the Chinese are, right? So he told me more or less, he's not technical, right? So I'm not going to say exactly what he said, but I can fill in the gaps, right? Like the things that he did not say, I can see how they would work. So putting what he told me and my technical knowledge together, this is what I think they're doing. They're taking the phone. So if I have the phone next to the computer while I'm working, right? Depending on how many keystrokes I type, because they can listen to the keystrokes, they can estimate more or less the length of a message. And the length of a message is an important feature that they need to know because it helps them narrow down the search space for the encryption key. Why? Well, because if they know that the message contains between 150 and 170 characters, they know that they need to be looking in the air, over the air, on the bytes that get transmitted, say via the Viasat antenna or via the cellular, whatever medium of communication I'm using, right? But they know they're looking for a string of more or less 160 characters encoded and encrypted, right? So that gives them a window, right? That gives them a search window. If they see a stream of bytes that is longer than that, they discard it, right? And if they see a string of bytes that is too short, they discard it. So this tremendously helps them isolate the signature of the transmission, right? Which helps them then brute force the encryption key. But what is amazing to me is how ingenious the Chinese are, right? Like, so they're listening to the audio using the box, and based on the audio, they're estimating the length of the messages that I'm transmitting. Imagine that. Oh, the split. This is a good one. Let me show you the split. So if you go to XisList.org, you have the directories, and I already described this in demo D98. But I added these two pages, which are kind of heat maps of the problem. So these are basically aggregated numbers of the top dogs. The top dogs are specific agents that match a specific criteria in my algorithms. The data is deterministic. The data is coming from the database of Teodoro Cabello, but the way I compute and organize them depends on my secret algorithm. Let's put it that way, right? So based on that, this allows you to see visually in the US, for example, the problem. Like it lets you understand the nature of the problem and the size of the problem, right? But there's a chart here that is very interesting. So here you can see, right, that there's a huge concentration here in Pennsylvania in this area, right, which is the mid Atlantic corridor, because you have Washington and specific places in Virginia, right? But what I want to show you more is, let me see if I can. Yes, what I want to show you more is this. Look at this. You see this perfect line over here? I mean, these lines, so these are zip codes, right? Zip codes where these top dogs are concentrated. I mean, these military positions marked in the database of Teodoro Cabello. Look, like the fact that all these zip codes align perfectly and split the US in half. I mean, it is impossible. I'm telling you this as a statistician, more than as an engineer. It is statistically impossible that this is a coincidence, that there is not random design behind this. And more than that, if you show this video and you show this to any person in the military, they will know that this is a military tactic. It's a well-known tactic. It's splitting the enemy in half. And this has been used in multiple military conflicts in centuries, for centuries, right? So here you can see the nature in that simple heat map. You can see the true nature of this organization, right? This is a military operation that the Teodoro Cabello is doing, operationalized with this database of the Chinese. So I wanted to, point your attention in that direction. Yes. So another big mistake was the following, right? And this is super interesting. I mean, this is something that has to be analyzed at some point, right? By I don't know, somebody who is what's the word? Equipped. Somebody who can understand. Like I imagine, right? Like I don't know. Let me tell you something. When I was younger, I used to play chess, right? And as a chess player, I wasn't a serious player, right? In fact, my friends would always beat me. But as a chess player, one of the things that you do, sorry, I missed. Okay. One of the things that you do is that you analyze the games, right? After you play a game, you study it, right? Or there are books, like for example about openings, and there are books that are dedicated to one opening, and in the book they study all the sequence of events and what happened and why he did that and what like they dissect the conflict basically, right? I don't know. Imagine when this gets to a resolution, somebody that is equipped to do it, because I'm not equipped to do that, right? Should probably analyze this, right? Like these mistakes that they make, why they made it, right? But I think it's because of the lack of coordination, because now they're not meeting they are meeting face to face, right? And this causes coordination problems. So this is what happened. As I'm doing, this is what I was doing in this very moment, right? I'm going to tell you the setup, the situation, so you understand why they took this step, right? Or why I think they took this step. So the situation was, I had filed that document I showed you that has the cover of the books and that has a copy of the IRS forms with everybody redacted except Troy Pickett, Judge Brown, and Judge Telfer. And I filed that with the 387 court. I did that, and then they took the clerk and swapped the document by the previous filing of Troy Pickett, which now causes that the index 147 is missing from the docket. Again, and this happened before, right? When they disappeared the index 7 from the docket, the mysterious temporary order that Judge Bell sign, and then they disappear and turn it into a wild card. Well, the same thing happened now. The index 147 is missing because they swapped my document with Pickett's. And of course, Pickett's index moved from 147 to 150 now, right? Or whatever, 151, I don't know what it is. So they did that on that day, on January 20, okay? At the same time, I was working on backing up my messages, my text messages from that phone that has the messages of the extortion messages of the Adams law firm are in there, right? So this is explosive evidence. I'm backing them up and about to upload them to the buckets, right? But they have this phone bugged, right? Heavily bugged. So they saw that, and this I'm imagining that this is what happened, right? And by the way, if the informant sees this, please let me know if this is what happened, right? I mean, if this is what triggered this crazy decision they made. So that's the setup, right? They have just pulled the trigger on swapping the documents in the docket. And I'm at the same time about to upload the extortion messages to Google Cloud. At that very moment, George Hanks Jr. sent an order in the federal case, which is the class action lawsuit against the commercial actors, right? So Elon Musk, Travis Kalanick, those people, right? For wiretapping and illegal surveillance. And it's a class action because I can see in the database that this is affecting at least, and I'm being very, very conservative here, because when you do a lawsuit of that magnitude, you want to be conservative, right? Like, I don't want to overestimate things and then that the lawsuit gets dismissed because I wasn't accurate, right? So I rounded down by a lot, right? So the numbers are much worse, but very, very conservatively, I'm going to tell you 20,000 people are targeted in this way, right? So I created this class action lawsuit 9 months ago, and they've been blocking it procedurally. It's a stalled, right? But as I'm about to upload the messages to Google Cloud, Judge George Hanks Jr. sends the order dismissing the lawsuit without prejudice, right? I believe this was a move, so I would stop my action of so I would get distracted, right? Kind of the same thing they did the other day when I started publishing the conflict zones of Russia. When I did that, Judge Hanks, well, the other judge, the magistrate judge, sent a recommendation recommending to dismiss the lawsuit. Like, it was a distraction tactic, right? This is what they do. When you do something that is worrying to them, they try to harass you to distract you, so your mind goes to another place, right? And that's the reason why they took the child, right, in April, because I was reporting people to the IRS and I was investigating addresses of important people in Caracas. It's a harassment technique designed to distract you, to shift your mind and your focus to someplace else. That's all. That's all they do, and that's how they, at the end, control the world, by doing this to everybody, right? To everybody that gets in their way. So it had already happened when I started publishing books about Syria and Ukraine and Israel and Gaza, the Gaza Strip. The magistrate judge in this very same case sent a recommendation to dismiss. And now, when I'm about to upload the damaging messages about the extortion directly employed by the Adams law firm on April, after they took the child without a valid order of any judge, Judge Hanks finally dismisses the lawsuit. I believe it was a way to distract me, but it didn't distract me, because I explained this before, right? I understand the situation because I have the data. So what I did, I finished uploading them. I really upload the messages, right? I finished doing what I was doing. And I had already set up an alarm for this in my system, right? Because this is a terrible, terrible mistake. And I think, and this is what I want to talk more about, the mistake, more about what happened, right? And that's what I was saying, that somebody should analyze this conflict later, right? I mean, somebody qualified. This is a terrible tactical mistake. So much so that I had a system in the legal vaccine pipeline set up an alarm to trigger an alert to me the minute this happened. And I had that set up months ago. Why? Because this lawsuit is a class action lawsuit. Like, this is a very different legal instrument or legal cause or action or case, very different than the trial court, right? The trial court is a case involving my parental rights, right? It's one individual. It's only me, right? And I'm nothing. I'm a grain of sand in this, right? If they violate my parental rights, I don't know how to articulate this, right? But in the bigger scheme of things, that's nothing, right? Taking one child for 9 months in the bigger scheme of things, like I told you this in one of the previous demos, right? There's at least 750 children targeted in this very same way by this very same network in Texas alone every year, right? So one child more, one child less is nothing, right? And think about it for a second, right? What I'm saying is really sad, right? That I'm saying that one child doesn't matter, right? That's what I'm saying. In the context of the complexity of this criminal enterprise, one child is nothing. And that on itself, it's deep. But anyhow, it's a terrible mistake because these elevate the stakes immensely, because this is a class action lawsuit attempting to preserve the civil rights of at least 20,000 US citizens. Right? So that action of that judge is not an action against me. It's an action against 20,000 US citizens. And this elevates the stakes immensely, morally, legally, from a penology point of view. The penalty, committing a crime against one individual is something very different than committing a crime against 20,000 US citizens at the same time, right? But that's what they did, right? So the minute they triggered that was a gift that they gave me, because now the conflict shifts. Like that, now this is not about me, because as long as that class action lawsuit was stalled, it was stalled, right? They could say, well, we're just slow to respond, right? But now it's not stalled. Now they killed it, right? So now they took an action affecting the civil rights of at least 20,000 US citizens. So what I did, this transforms the conflict, right? So I created a new book for the DOJ, which is reframed from the perspective of, it's the same information, right? It's the same compilation of filings, but it's reframed from the angle of what they're really doing, which is violating the civil rights of 20,000 at least. And I'm being very, very, very conservative when I say 20,000. Believe me. It could be orders of magnitude above that. But, for the sake of the argument, let's say 20,000. So this judge is directly contributing to perpetuating a situation in which a narco-terrorist organization led by an individual wanted by the DOJ and the DEA keeps violating every single day the civil rights of at least 20,000 US citizens. Put that in perspective. Right? So with that, I'm going to show you the new book. So the new book. So if you go to XisList.org, is the first book that you will see is the criminal complaint, right? In this page. It's this one that has this color that looks like a folder. Let me show you first the okay. Let me show you the book. Okay. So the title is The January Docket, and the subtitle is A Record of Coordinated Obstruction of Justice and Judicial Enablement of Mass Civil Rights Violations and a formal criminal complaint and supporting documents submitted to the Chief Public Integrity Section, Criminal Division, U.S. Department of Justice. And it says clearly in the back cover that the allegation is that the judiciary actors are actively enabling the continuous daily violation of the civil rights of at least 20,000 US citizens. It's said right here in the back cover, okay? And if we explore the book, it's organized from that perspective, right? Not from the perspective of they kidnapped my child, but now from the perspective of they are violating the civil rights of 20,000 people in the US alone, right? And there's a brief introduction. Just trying to find the index, right? So this is an example, right, of how they make a mistake that is a terrible legal mistake. And it's amazing to me that they cannot see that, them being judges. I mean, what kind of judges are these, that they can't see that what they're doing is disastrous, right? From a legal point of view. I mean, I don't, how do I say this? I'm respectful of people on their fields. Like, I never talk down on anybody. I don't do that on principle, even if I think that somebody is underperforming on their job, or like I'm never a mean person saying, you don't know what you're doing, or I'm not, that way. I'm not built like that. I'm more of a constructive person, right? Than a person that criticizes, right? But here I have to say, I mean, the logical question that I have to ask myself is what kind of judgments these judges have issued in the past if they are not able to see these legal mistakes they're making. I mean, it's inevitable for me to ask myself that question, right? To question, the soundness of those judgments, right? That they may have made in the past in other cases, right? I don't know. So this clearly explains, right, the two federal cases, how they blocked them, and how they're enabling the continuous violation of civil rights that are protected under the Wiretap Acts, both nationally and in Texas. And in other states, they have their equivalents to that, right? With different degrees of strength and severity, but they exist in every single state. Then the second part of the book talks about the retaliation and the evidence tampering, for example, with the two clerks that I described before, right? And all these things are documented here with exhibits, proving or showing what they did, with their own signatures, right? Everything is in here. And this has 753 pages at this point. And then the third part of the book is what I call the indictment, which is really the formal complaint to the DOJ, submitted to the DOJ with all the supplements. And right now in this version of the book that you're seeing, it has 6 supplements because I haven't updated it, but now there's 2 more. There's 1 supplement for the 7th supplement, which is the obstruction by not filing the document that is a vital document for my motion to recuse, which is the only instrument I have to get a fair trial, right? The clerk refused to file it, and the clerk on the 5th Court of Appeals refused to file my motion to the court, not to the clerk, to the court, to force the clerk to file my motion for a stay. So this kind of redefines, right? I mean, what that clerk on the 5th Court of Appeals is doing redefines the meaning of the word motion, because until now, the word motion in legal circles meant that you try to move the court to take an action. But nowadays, one does not simply move the court. One moves the clerk. I mean, that's the meaning that they gave it to the word, right? But anyhow, there's 2 supplements. The other supplement is Troy Pickett, right? Because then after this morning, and I don't know if this is probably a good place for me to stop it because it's getting too long. But this morning, after I understood the angles, right, the intersection between RICO statutes and admiralty law and death penalty status and terrorism-related status. Well, what I did is that I filed with the 387 court a notice, putting all of them in notice that what they're doing is participating in a terrorist organization, and the implications on the federal law about the terrorism enhancement of the penalties of the people that are doing this. And I'm just reciting in this notice. I'm just reciting the law, right? I'm just telling them I'm just putting them in notice. They should know, right? Because they're lawyers and attorneys and judges, right? But in case they don't know, I'm putting them on notice of what the federal law says, right? About the penalties that these things could carry. In fact, let me show you the notice. So if you go to this bucket, right? Let's pick the 387 court. For example, if you go to William Kyle Adams and you go to his folder, I filed a notice of treason, and I know it sounds alarming, but it's true, right? I mean, it's legally speaking, it's accurate, right? I'm not putting anything in here that doesn't apply. So the title is Emergency Verified Notice of Ongoing Conspiracy to Commit Terrorist Acts and Treason in violation of 18 U.S.C. 2381. So I'm telling them that you can see I think I'm gonna read this, right? So factual predicate. A hearing is scheduled for January 22nd, 2026, which is in a few hours, to enforce a void order and seek sanctions, including incarceration. And then I'm saying that and this is the important part that I want to tell you here, that when I filed this document, which was at 12:10 p.m. U.S. Central Time today, until that point, Troy Pickett had not filed any exhibits for tomorrow's hearing. And think about it, right? He scheduled this hearing to supposedly seek enforcement of the void orders, right? And the sanction orders and all that. Well, he said the orders, right? He was intentionally vague about which orders he was seeking enforcement for, but because of what he filed, it seems like he's seeking enforcement of the temporary orders. But anyhow, I'm saying in this notice that until noon, until that point, he had not sent me the exhibit list for tomorrow. And this proves that the intention of that hearing, well, it's either one of the two, or he knows something that nobody else knows, right, about how this court functions, that he's so confident that he can get the judgment he wants tomorrow that he doesn't even need to file one document. And he's seeking enforcement and sanction, like the monetary demands he's making for tomorrow's hearing is over $30,000. And he's so sure that he can get it without filing a single page of a document that he didn't file anything, right? And in his own notice of hearing that he filed with the court, it is said that the deadline for exchanging exhibits was at noon the day before the hearing. So past noon, he had not sent anything. And I'm putting him on notice here, right? Because this shows that this hearing is not really a hearing. It's either an intimidation tool, right, to intimidate a whistleblower and an informant, or it's a hearing that has a predetermined outcome, that he knows that he doesn't need to file anything, right? Because he's going to get the judgment that he already determined, right? It's one of the two. So I tell him that, right? And then I in the same notice, I put them on notice of the federal statutes about, things like witness tampering, which in the context of terrorism, in federal law, it could carry a capital punishment, right? I also tell them about the terrorism enhancement, which is USSG 3A1.4, which tells them that the crimes committed in this context could be reclassified as terrorist acts because they are participating in tampering with a witness with the goal of concealing information about a terrorist organization, right? Diosdado Cabello's organization. And this could lead to sentences of 20 years to life. And finally, treason, right? Because this is a foreign organization commanded by Tesoro Cabello, who is a military figure of a foreign nation, right? This is treason. So providing aid and comfort to a foreign nation to do this is treason. So anyhow, after I filed this today at afternoon, like at 12:30 or something like that, a few hours pass, and then Troy Pickett, 1 hour before the court closes, files an exhibit list, which has supposedly a financial statement of the petitioner. I mean, he just filed the list. I didn't get the statement. He just sent me the list of exhibits, but he didn't send me the exhibit. Anyhow, this is a tremendous mistake, because he's acknowledging, by that action, he's acknowledging that he received this notice. It's a direct confirmation that he read this notice, which puts him in notice of the, and that's why I designed it that way, right? I don't want to say a trap, right? Because I'm not playing with the court, but I designed the document in a way that, if he took action, it means that he's confirming that he knows about the federal statutes, right? That I'm telling him in the same notice. So anyhow, he went for it, and he confirmed that he received the notice, right? So he's on notice because he took action, the action that the same notice is saying that he didn't take before. He took it within hours, right, after I sent the notice. And of course, if the clerk dockets his document but doesn't docket mine, 3 documents that have been pending for 2 days, then this will be the smoking gun against the clerk. And this document, it's a brilliant. This was designed by the pipeline, by the way. Anyhow, yes. So he gave me that confirmation, right, by filing that. But that's what I was saying, because the document that he chose to file was a financial statement of the petitioner. It sounds like he is going to supposedly allege that she's in distress financially, and so it sounds like he's seeking enforcement of the void orders, because the motion for sanctions had nothing to do with the financial situation of the petitioner. Sanctions are sanctioned for sanctionable behavior of, supposedly, me, right? In his mind, not complying with the void orders. But the fact that he is filing that suggests that what he's seeking enforcement of is the void orders, which could be a move to lower his liability, right? Because he's going to say, I'm not seeking to imprison you for the sanction motions, for the sanction order. I'm seeking to imprison you because of the void orders. But that on itself would be even worse. Why? Because it would be confirmation. I mean, it is confirmation that he's seeking enforcement of the void fraudulent order, again, that has no validity. So this is wire fraud again. This is another count of wire fraud, and another count of attempting to silence a whistleblower and a federal informant using a void judiciary instrument, a void order, right? An order that is null, that doesn't really exist. So this is worse, right? It would have been better if you had seek enforcement of the sanctions, I think, right? From looking at the pipeline, this is much worse. And with that, I'm going to move on to another move that also, came from the software. I did this thing where I sent an email, because they've been blocking the filings, right, with the clerk. So I sent an email to Rebecca Bright, who is the clerk of Judge Brown. Judge Brown is the administrative judge that would review the motion to recuse, right? So I sent her an email saying, hey, my filings are being blocked by the trial court, and as I understand, you have received the motion to recuse. I want to ask you, what is the procedure to give these documents to Judge Brown, right? Of course, I know that she replied, she made the mistake, and she replied. She replied saying, we have not received your motion to recuse. And this is a terrible mistake. I mean, it's a mistake so basic that it makes the hair on the back of my neck stands up, right? When I think about how horrible this mistake is. Because she's giving me written confirmation that Judge Telfair never forwarded the motion to recuse to her. And Judge Telfair has an obligation. This is not discretionary. He has a ministerial duty to either, I mean, if he doesn't want to recuse himself when he receives the motion to recuse, he can do that, but then he has the obligation to forward that motion immediately. He cannot let it sit in the docket for a week. He has the obligation to forward it to Judge Brown immediately, and he didn't. And more than a week has passed, and we have that hearing tomorrow. So he is obstructing justice. He intentionally did not forward a motion to recuse that he's obligated by law to send to the administrative judge. He didn't send it. He just let it there sit to get me to a point where he could get me into that hearing tomorrow and put me in prison, right? Conspiring with Pickett. But this is amazing because this is not me saying it. It's the clerk of Judge Brown saying it, right? I mean, this is a judiciary official on a court that is an administrative court that manages the 387 court. And an official of that court, the clerk of Judge Brown, is telling me that Judge Telfair failed to fulfill his obligation of forwarding the motion. I mean, there is no better proof than this, right? So what I did, of course, I created an A supplement and I sent it to the DOJ. I'm not going to litigate with Pickett, right? The silly document he filed with the exhibit list, right? I'm not going to get into that trap. Of course, I also sent that to the DOJ. But I sent a copy of the email. That's the 7th. The 7th supplement is the copy of the email of Rebecca Bright, confirming that Judge Telfair did not forward the motion to recuse. And he hasn't ruled on it either. So he didn't rule on it and he didn't forward it. The two things that the two paths he could take, he didn't take either of them, right? So this is the abdication of a judicial function. That there's no other way to put it. The judge stopped being a judge. Like he didn't do any of the things that he could have done on such a grave matter as the motion to recuse, and particularly being on the record asking from the bench the respondent on the stand if those were my books, the books that talk about him directly and the alleged misconduct of the judge. I mean, if I had a mic, I would drop it at this point. But you know, I'm using this. So I can't really do a mic drop. So before I go, I want to show you this, right? So this is a printed book. And you know, I want to show you this because you know, like seeing it printed. I mean, it's a huge book, right? And this is only one book. This book that I have in my hand is. Let me show you this. So this is Afghanistan, right? So this is the book of addresses in Afghanistan of the network of Diosdado Cabello. And I don't know if this will be visible to you, right? But like, look at how big this is, right? So this is 800 pages. And if you look at the pages, they're printed with very, very small print, like basically size 6, right? I'm gonna try to show you, right? So, I mean, it's hard to put into words what I feel when I see this, right? Because imagine this book is filled with properties that were purchased using drug money of Diosdado Cabello and that are used to enslave people all around the world, right? And this is just Afghanistan. Like this is only one place, right? I have published more than 100 books at this point of different places in the world. So I don't know. I wish somebody at the DOJ could have the opportunity to print one of these books so you can get an idea of the size of this problem. Because it's not the same, believe me, even me that I have had the database for a year, it's not the same seeing this on a screen that having this device in your hand. Like having this, like somehow grounds in your brain the reality of the gravity of the situation. Like these pages are filled with locations that are controlled by Diosdado Cabello, right? And that were acquired with drug money. Now, that on itself, and like I've said this multiple times before, like I tend to be positive, right? To look at the bright side. There's a bright side to this, believe me. I think. And I haven't really thought about how to put this into words, right? But it's something like this, right? The thought. I'm gonna walk you through my train of thought. Okay. It's something like this. I've seen firsthand how these people allow no competition, right? And I've seen this through a period of more than 20 years. Every startup idea that I've had, they stole it and then kill it, right? They never let me do one startup, no matter how small it was. Like they don't allow competition of any kind. That's their nature. Right? They're predators. Right? They predate anything that competes with what they're doing. Right? And even if they're not doing the same thing, when they see something, even if they're not doing it, what they do, they steal it, they kill it, and then they do it. Right? They adopt it themselves. Right? But anyhow, the thought is that knowing that that's their nature, right, and that Diosdado Cabello, who is running a large scale drug organization, are in the same network, right? It seems obvious to me that they probably, Diosdado Cabello probably has the worldwide monopoly of the drug trade, because I cannot believe that they would allow a competitor to survive. If they don't allow a competitor to survive on the technical companies in the US, I imagine Diosdado Cabello is not going to allow a competitor in the drug trade to survive. It's just pure logic, right? So what that means is that Diosdado Cabello is an aggregator as well of the drug trade. And the bright side on that is that capturing Diosdado Cabello means the end of the drug trade. And that is a bright thought for the world. You could put, I'm talking to the DEA, you could put an end, literally, to the drug trade by taking Cabello. So with that thought, I think it's a good place to end this conversation. Again, thank you for your time. And let's see what happens tomorrow if they take the step to go for life in prison or if they play it cool. Let's see what happens. Thank you again, and I'll see you tomorrow, hopefully.